This video is for educational and infotainment purposes only. It is not intended to encourage or glorify the use of illegal drugs, violence, or criminal activity in any way. Ismael Zambada-Garcia, aka El Mayo, considered by many to be one of the most successful drug kingpins in history, is in custody in the United States after what is rumored to be a betrayal by co-cartel leaders Los Chapitos. He has now had 2 court appearances in El Paso, Texas. So what happened during each court appearance? Well, you're about to find out. I'm Joshua Roberts, attorney at law, and you are watching Lawyer Up. This is episode 2 on what will be numerous updates on the arrest and trial of El Mayo. We will also be updating on what is happening with the other members of leadership with the Sinaloa cartel that are in custody, including 2 members of Los Chapitos, Joaquin Guzman Jr., who was with El Mayo at the time of his arrest, and Ovidio Guzman, who was arrested some time ago. Both of those 2 are sons of the legendary trafficker El Chapo. So if you are unfamiliar with the arrest, you will need to go back and catch up on episode 1 to fill you in on all of the details. We're going to start this episode with El Mayo's arraignment on July 26th of 2024. Now, arraignment is a big scary word to people in criminal law, but it's actually quite simple. An arraignment is just an appearance in front of a judge where the judge provides a written copy of the charges and/or reads the charges to the defendant if requested, and then he enters a plea. 99.9% of the time in federal court, the plea that is entered is going to be not guilty. Now, that may change at a later date by way of a plea hearing or a trial, but it starts off with the entry of a not guilty plea. And that is exactly what happened when El Mayo appeared with his attorney in court. Now, I wasn't there, but I've handled hundreds of drug cases in federal court. And generally what occurs is that the judge inquires as to whether we have received a copy of the charges. My response is generally that I have received a copy of the charges, that I have reviewed them with my client, that we would waive a formal reading of the same and enter a plea of not guilty. This is generally followed by an inquiry from the judge as to whether we desire all of the discovery to which we are entitled, which of course we say yes. The same inquiry is made of the government if they seek all of the discovery to which they are entitled, and they obviously will also say yes. And then the court generally will follow that with the entry of a scheduling order which defines when the trial will take place, along with other procedural deadlines in the case. An arraignment hearing usually takes about 15 minutes, and in the case of El Mayo, who appeared before U.S. District Judge Kathleen Cardone in El Paso, he entered a plea of not guilty, and a trial was set for September. Discussions during the hearing also included whether Zambada would be tried with other co-defendants or separately. On August 1 of 2024, El Mayo was back in court with his lawyer for a status conference and detention hearing. A detention hearing is simply a hearing to determine whether the defendant will be released on bond prior to his plea or trial date. And there are several factors that the court looks at in determining whether somebody will be released on bond. The factors are outlined by the Bail Reform Act of 1994 as well as Supreme Court case law. The act requires the court to detain arrestees charged with certain serious felonies if the government demonstrates by clear and convincing evidence that no release conditions will reasonably assure the safety of the community. The act provides arrestees with a number of procedural rights at a detention hearing, including the right to counsel, the right to testify, the right to present witnesses and evidence, and the right to cross-examine witnesses. The act also specifies the factors to be considered in making the detention decision. So what factors do the judges consider? Well, the key factors include, number 1, the nature and circumstances of the charges. The more serious the charges often weigh in favor of detention. Judges specifically consider if the case involves crimes of violence, terrorism, sex crimes, or offenses with lengthy prison terms. Next, the judges look at the weight of the evidence. Judges assess the apparent strength of the government's case. A strong government case often points towards detention. Then they look at the history and characteristics of the defendant. Judges will review factors like a prior criminal record, history of violence, ties to the community, employment, health conditions, and more. Next, judges look at danger to the community. Judges will evaluate whether a release would pose a threat to public safety. Dangerousness weighs heavily in favor of detention. And yes, drug trafficking is considered to be a danger to the community. Then judges look at flight risk. They will assess the risk that the defendant may flee or fail to appear for future court dates. A high flight risk supports detention. While judges consider all of the factors, the two that carry the most weight are traditionally danger to the community and flight risk. So in evaluating each one in regard to El Mayo, you first look at how serious the charges are. In El Paso, he is charged with drug trafficking, which is a Class A felony. And it doesn't get more serious than a Class A felony with the range of punishment up to life. So they are very serious charges. Next is the weight of the evidence. We know there is an enormous amount of evidence that was produced during El Chapo's trial. And since these two conspired together, that evidence would also be usable against El Mayo. So the strength of the government's evidence, given they have a conviction of a co-conspirator, would be very high. Next is the history and characteristics of the defendant. Interestingly, El Mayo has no criminal history. He has no convictions and he's never been incarcerated. Now, the court will also look at charged conduct, and in the present and other cases, it will be an evaluating factor. However, when it comes to actual convictions, this flows in El Mayo's favor. Up next is danger to the community, being charged with murder in another court case and being the largest trafficker in the world of fentanyl, methamphetamine, and other serious narcotics into the United States probably will make you a danger to the community. Hard to imagine anyone that would be of more of a danger to the community when it comes to drugs, and that definitely favored detention. And last but not least is flight risk. When I am analyzing this factor for my clients, I'm looking for long-term ties to the local community. I'm looking for a house, a job, a family, kids, etc. I'm looking for reasons why my client would not run. So when it comes to El Mayo, he has none of those things in the United States. So I can't imagine anybody on planet Earth that would be a greater flight risk than Ismael Zambada-Garcia. So at the end of the day, the factors weighed heavily against the release of El Mayo. In fact, his attorney didn't even argue for release and waived his right to a detention hearing. So El Mayo will not be released on bond prior to trial. So that's where things stand at the moment. We have an upcoming video detailing what El Mayo is charged with in his various court cases around the country and the talks of them transferring him to New York. Make sure you subscribe to the channel to get the updates regarding this matter as it proceeds through the court system. If you're interested, check out my full-length video on Zambada's life, detailing how he got his start in trafficking in the 1970s and his transition from the Juarez cartel to the Sinaloa cartel. That is all for today. My name is Joshua Roberts, attorney at law, and you've been watching Lawyer Up.